Good evening, ladies and gentlemen. Welcome to tonight's edition of HR Mentorship Learning Series. On this platform, we never get tired of learning. Someone reached out to me recently, said, how do you guys do it? I said, the same way we watch Premiership back to back weekend, the same way we watch, what do you call it? The series in movies. That's the same way we pay attention to our learning and development. We are going to be so good, results will be inevitable, and we will succeed and excel as HR professionals. Tonight, we have one that is someone that is very special to us and to me. Emmanuel Abraye is a barrister. If I'm not mistaken, this is the third or fourth time he's coming to this prestigious platform, and graciously, magnanimously, is going to be speaking to us on a topic we have entitled Unfair Labor Practice, the Obvious and Gray Areas. Unfair labor practice, the obvious and gray areas. In case we have a first timer with us tonight, or we have someone who by chance does not know who barrister Emmanuel Abraye is, I will read his profile quickly. Emmanuel is a senior counsel at Pinnacle Oil and Gas Limited, an indigenous oil and gas company active across the entire downstream value chain, with emphasis on petroleum trading, marketing, distribution, retail segment of the Nigerian oil and gas sector. Emmanuel, prior to joining Pinnacle, led the Labor and Employment Practice Group at Petstone and Grace LP, where he was also a core member of the firm's litigation, intellectual property, startup, and banking and practice groups. Emmanuel was recently selected by Who is Who Legal's independent research with clients and peers as being among the highest ranking lawyers in Nigeria in labor and employment, and will be included in the 2023 report. Emmanuel was a co-contributing editor to the Nigerian chapter of the Employment Law Review, a UK-based publication in the year 2022. He has also contributed to many periodic updates on varied spectrum of labor and employment law, including diversity and inclusion in the workplace, workplace gender rights, and general employee rights for Square Patton Boggs online publication on labor and employment, and a number of many other employment-related publications. Emmanuel has been opportune to be invited as a speaker in a number of events and radio shows, including the Chara Institute of Personnel Management of Nigeria, The Office on Lagos Stocks 91.3 FM, as well as the weekly HR Mentorship Learning Series, where he's back again tonight. Emmanuel is a member of the Nigerian Bar Association and its Young Lawyers Forum. Ladies and gentlemen, my name is Oluyemi Adeosun. It is my privilege and pleasure to hand full control to Emmanuel Abraye Esquire. Let's show him some love with emoticons and emojis. You are welcome, sir.
Thank you very much, Mr. Adeosun. I'm very grateful for the opportunity. It's always a delight to speak to HR professionals, and this is my first time, and I'm always happy to be here. Today, I'll be speaking on unfair labor practices, the obvious and gray areas. And I have outlined a number of things that we'll be looking at in today's topic. And we'll start by making an attempt to define unfair labor practice, after which we would look at how it was introduced into Nigeria's labor jurisprudence. Then we would look at the current practices that have been declared as unfair, and then we'll look at the gray areas of unfair labor practices. Then I'll look at what your responsibilities should be as HR personnel, and then we'll conclude. I'll start by saying that in Nigeria, there's really no definition for unfair labor practices as we know it. The definitions we would have are really just definitions that we have drawn from other jurisdictions where we have unfair labor practices somewhat defined. And of course, there are dictionary definitions that we can rely on in trying to delimit what unfair labor practice is. Unfair labor practice, though it is constitutionally recognized in Nigeria by virtue of Section 254C, subsection 1, paragraph F of the Nigerian Constitution, which is basically that portion that grants the National Industrial Court of Nigeria um, the jurisdiction over unfair labor practice and international best practices. Aside that mention of unfair labor practice in the Nigerian Constitution, you do not have it mentioned anywhere else in any of our laws. And so, what has really brought about unfair labor practice is really that mention in the Nigerian Constitution, by which the Constitution gives the National Industrial Court the power to exercise its jurisdiction over unfair labor practice. Now, notwithstanding, the concept of unfair labor practice is clearly the attempt by the law to denounce practices that are unfair in the workplace. And we'll get to what those practices are in a short while. Merriam-Webster's dictionary defines unfair labor practices as any of various acts by an employer or organization that violates a right or protection under applicable labor laws. So we know that whatever unfair labor practice can be defined to be, it must, at least at this stage of the discussion, have its roots in laws and, of course, applicable labor laws within your own jurisdiction. And why it is jurisdiction specific is that some things that might be said to be unfair labor practices in other jurisdictions might not necessarily have the same meaning or application in your own jurisdiction. So we'll be limiting ourselves to Nigeria as our jurisdictional scope. So to define it again at this stage, unfair labor practices can generally be seen as any of various acts by an employer or organization that violate a right or protection under applicable labor laws. Now, of course, I know that many of you would have questions. Why just the employer? Are employees not also involved in unfair labor practices? We'll get to that shortly. By Section 12 of the Nigerian Constitution, a treaty can have force of law when it has been enacted into law by the National Assembly. Now, I'm trying to track back to why we have unfair labor practices. I have explained earlier on that the reason why the phrase unfair labor practices appears in our labor jurisprudence in Nigeria is because it was mentioned in the Constitution. Now, that mention, now is what I'm trying to explain. You recall that if you were part of that session, I had once spoken here about international best practices, and we had talked about the application of international best practices in labor relations in Nigeria. We had talked about how international best practices, came to be, and what we had said at the material time was that we could draw international best practices from international labor standards, and that these international labor standards are depicted in international conventions, international recommendations that impinge on labor-related matters. Now, we then said that for you to be able to say something is an international best practice that is applicable to Nigeria, then it must be that Nigeria has ratified a particular international convention, or that that international convention has been domesticated into law in Nigeria. Of course, I also explained that there are instances where the international convention may not be ratified, but then can be used as evidence of international best practice. Now, Section 12 of the Constitution ordinarily requires that before any of these international conventions can apply in Nigeria, they must be passed into law or enacted into law by the National Assembly. However, the National Industrial Court has a special jurisdiction to enforce international conventions that have been ratified. That means Nigeria is a signatory to that convention and it applies to Nigerians. In Nigeria, the laws that impinge on employee relations include international conventions. Whether those international conventions are of the International Labour Organization or of any other international organization like the United Nations, the African Union, so long as those conventions are ratified by Nigeria and they apply to international relations, then they are ordinarily applicable. Of course, I earlier said again, unratified international conventions are nonetheless evidence of international best practice. Now, you would recall that I had said that if you are defining unfair labor practice, it has to have its roots in an applicable labor law. But then we have also talked about the fact that international best practices are applicable also by virtue of the Constitution. And international best practices can be found in ratified conventions. But then that unratified conventions can also be the source of international best practices as they stand as evidence of what those best practices are. So to that extent, you could also say that unfair labor practice could also extend to include violations of the provisions of unratified or ratified international labor instruments, whether or not they have been domesticated into law. And the definitions, the possible definitions of what international best practices could be are not closed. So you would find that from time to time, something that was not declared as an unfair labor practice as of today might be declared as an unfair labor practice tomorrow, depending on what the state of the law is at the material time. Now, but then it is very important for you to understand what the state of, the ILO conventions are as relates to international best practices, because you really cannot talk about unfair labor practices without looking at fair labor practices, which of course is what is basically, the international best practices that, the Committee of States agree would be the practices that are best in labor and employment relations. Now, Nigeria has ratified 42 of the 190 ILO conventions. Of the 42, 26 are currently in force. There are certain conventions that are known as the fundamental ILO conventions. All of those are ratified by Nigeria, except one, which is going to come into force later on in November 2023. The fundamental ILO conventions, as I said earlier on, include the Forced Labor Convention, Abolition of Forced Labor Convention, Freedom of Association and Protection of the Right to Organize Convention, Rights to Organize and Collective Bargaining Convention, Equal Remuneration Convention, Discrimination, Employment and Occupation Convention, Minimum Age Convention, Worst Forms of Child Labor Convention, and other ILO conventions ratified by Nigeria, which are not part of the fundamental conventions, also include two governance conventions, which includes the Labour Inspection Convention of 1947 and the Tripartite Consultation International Labour Standards Convention. Those are the two governance conventions. Then you also have technical conventions. And the reason why I'm drawing your attention to all of these conventions is that these are the conventions from which you can draw international best practices from. These particular conventions, Nigeria agrees that these international best practices that are evidenced or contained in these conventions should be applicable to labor and employment relations in Nigeria. So it is very important for you to take note of what those conventions are. So it's easier for you to decide how you can relate with your employees and also advise management in accordance with what you have in all of these conventions. So the technical conventions include the Right of Association and Culture Convention, Equality of Treatment, Accident Compensation Convention, Minimum Wage Fixing Machinery Convention, many other conventions like that. Of course, there is the Violence and Harassment Convention, which will come into force in November 8th of 2023. This is because, of course, Nigeria still has the right to lodge formal disagreement and the rest of those technical procedures. I have said earlier on that the reason why we are having a discussion about unfair labor practices because of the Constitution. There was a major amendment of the Constitution, which is called Third Alteration Act, which amended the Constitution and introduced a section 254A, B, C, D. These provisions of section 254 created the National Industrial Court. Well, not necessarily created, but I mean, giving it the constitutional power, recognizing that court as a court of record, you know. Now, we are having this discussion because the phrase unfair labor practice appears in the Constitution just once in section 254C, sub 1, paragraph F. It appeared just once in the Constitution, but this appearance in the Constitution is very defining, and it has changed the landscape of labor and employment. And it's very important for you to understand why it is important. That provision just says National Industrial Court now has jurisdiction to apply or to enforce or to deprecate unfair labor practices or to discourage unfair labor practices or to penalize unfair labor practices in Nigerian employment relations. Now, it's not that there had not been such practices being condemned by the courts before the phrase unfair labor practice appeared in the Constitution. It is just that the phrase has now appeared in the Constitution. Of course, there were cases like the Court of Appeal decision in Afra Chemicals Limited versus Owodunyi, where the Court of Appeal held that the court must not allow the imposition of several conditions on employees by their employers. As it is now, unfair labor practice is now a constitutional issue, and the National Industrial Court has declared in a recently decided case that it has a sacred duty to prevent unfair labor practices. That's in the case of Ikena and Olaopa, and the decision was handed down by Honorable Justice Aruwo Shegbe of the Enugu Division of the National Industrial Court. Now, let's look at the labor practices that are currently defined or declared as unfair. I must state here that some of the practices you'll be seeing, some will be clearly unfair labor practice. You see it for yourself that, oh yes, truly this was unfair. Some of them you would wonder, why was this said to be unfair? Now, what I should also let you understand is this. And that is why I've always advocated that HR practitioners must keenly follow the decisions of the National Industrial Court, because it's the decisions of the National Industrial Court that would help you see what you should be doing and what you should not be doing. Now, the reason also why you follow the decisions of the National Industrial Court is that once that decision has been handed down and there is no appellate decision striking that decision down, that decision is law and it must be followed. Now, through decided cases, which of course, as I have said, are law, there are certain actions of employers that have been declared as unfair labor practices. In the case of Olabode Oguntale and 64 others versus Globacom, the following were listed as unfair labor practices: failure to issue written particulars of the terms of contracts of employment. This should, now, of course, you know that the Labour Act gives a timeline within which you must put down the terms of your employee's contract into writing. Now, you cannot just say, oh, you're employed, and then orally, then say, oh, you're employed, and then the person doesn't know the terms of his employment, doesn't know what the KPIs are, doesn't know what the, you know, what is expected of him as an employee. He doesn't know what his job description is. He's just employed and he's just hanging. So there is no letter or anything. This is an unfair labor practice. Now, stopping the issuance of pay slips to employees is also an unfair labor practice. Now, failure to allow your employees to go on annual leave or to pay leave allowance and overtime allowance is also an unfair labor practice. Now, this is why this particular particular item might be an unfair labor practice. If you have placed it in the contract of employment that employees will be entitled to annual leave and that upon their entitlement to annual leave, they will be paid leave allowance and overtime allowance whenever they work beyond the normal time of work, and then you do not do it. It's an unfair labor practice. When you compel, now, I've earlier said that some of these things I would say would be obvious to you as unfair labor practices, while some of them you would wonder why they tend to be unfair labor practices. Compelling employees to bank with a specified bank that you as the employer has chosen is an unfair labor practice. If you ask me why that is an unfair labor practice, I really might not be able to answer why it's an unfair labor practice. But then it goes to the freedom of choice, allowing your employees to decide which bank they want to bank with. Now, forcing them to register with a particular bank, I know that many times it's for ease of payment purposes. Sometimes you would rather just have the very bank that the organization is banking with be the same bank paying salaries to employees within the same bank. What I also know maybe is to help with bank charges and all of that. But an employee is entitled to decide which bank he wants to have as the bank to which his salary will be paid. And if you force them or you insist that they have to bank with a particular bank, then it's an unfair labor practice. Of course, when you open virtual salary accounts for your employees, these virtual salary accounts are demeaning of the employees and amount to unfair labor practice. Now, virtual salary accounts are accounts where you could have all your employees. It's just one account number. And but under that account system, none of them open the account. They don't have account opening information. They don't sign anything. They just are listed as beneficiaries under the account. And under that system, they will just have a particular sum of money that is attributed to them from which they can draw. Now, the only thing the employee has in the virtual salary account is an ATM card. Now, the court has said that is an unfair labor practice, and that decision was in Bupai versus Ajuba Nigeria Limited. Of course, if you dismiss an employee on false allegations, it is an unfair labor practice. You can't just, again, you can't just make allegations against an employee without giving that employee the opportunity to defend themselves. That's the international best practice on that point. If you have made an allegation of a wrongdoing against an employee, that employee has the right to defend themselves against the allegation that you have made. But if you just make an allegation and then it turns out to be false, and you have dismissed that employee based on that false allegation, it is an unfair labor practice. Of course, that's obvious on the face of it. When you dictate to an employee where to invest his or her completed gratuity benefits, it's an unfair labor practice. Now, there is no decision yet on the point, but for those of you in organizations where you have stock option plans for your employees, when you are insisting who they should sell to when these stock options are vested, that is obviously in line with this decision. It can be extended and said to be an unfair labor practice. Basically, when you're trying to influence the decision of your employee one way or the other with relation to accrued rights, it is an unfair labor practice. Of course, the decision in Honora versus Access Bank is limited to completed gratuity benefits, right? But it can also obviously be extended to include other things that are not related to gratuity benefits, so long as it is you trying to force your employee against what they would normally have done. If your employee decides that he's collecting his gratuity today and wants to spend it all on drinking, you cannot say that you want to be a savior to try to save that employee from doing what you think is terrible for him. And then you want to save him to do what is right. And then you forcefully, retain the gratuity benefits that, oh, he's a stupid man. We know him. He'll go and drink. His children will not benefit from this. And then you decide, oh, well, I think it's best for me to hand it over to his next of kin because we know this man is a useless man. We've only just harbored him and accommodated him in this office. Let his children not suffer for his own doing. Even though your intentions are good, oh, that action will be an unfair labor practice. When you vindictively suspend someone or you vindictively deny someone of their promotion, it's an unfair labor practice. You see, many times um, we fall into the trap of solving problems superficially. So you have a situation where an employee has maybe reported his superior in the office. And of course, the superior was at fault, or maybe something happened, there was a whistle blowing, and then a subordinate employee was asked to testify. The subordinate employee testified against his superior. And then you, as HR, fail to do what is necessary to shield that subordinate employee from reprisals, from reprisal attacks or from retaliation from that superior employee who is now disgruntled that a subordinate employee has, testified against them. And then you now start finding out there's no um, performance evaluation being done for that particular employee. So every promotion cycle comes and goes, he gets nothing, you know, he's not promoted, and you have found out that it is vindictive. This superior employee is obviously just retaliating against the subordinate employee. It is an unfair labor practice. Let's move on. There's this thing I find HR people do many times, and I can tell you right here, it is unnecessary. I see it on some chat groups, and I always wonder. You see, if an employee has resigned, they resign. All those emails that you write saying we hereby accept your resignation is unnecessary. You see, if you write to refuse an employee's resignation, it is it that relationship between you and that employee immediately morphs into forced labor. So all those emails you write when an employee has resigned, and then you say, "Oh, we hereby write to accept," or "We hereby write to reject your resignation," it really goes to no issue. The employee's resignation and the cessation of employment between your company and that employee begins the day he tenders his resignation. And if it's a notice of resignation, it begins to take effect from that day, and there's nothing you can actually do to stop it. So when you insert clauses in your employment contract and you say that the employer is reserving the right to reject resignations, that is an unfair labor practice, regardless of what the point is that you're trying to make. Sometimes it's dicey because you have a situation where this particular employee who is resigning has done something wrong. Maybe he even defrauded the company. You must learn to, you know, um, enforce the company's rights in a different way, separate from that employment relation. So let's say someone stole in the company, stole a lot of money, and then he was caught and then immediately resigns. Hey, it's not a problem. Why do you want to hold him back? He has resigned, he has resigned. Then you pursue him with police and institute criminal actions against him or debt recovery actions against him to recover the money that is lost. You don't say, "Oh, we are rejecting your resignation." What exactly will you do with the rejection of the resignation? Will you then constitute yourself into the police? Will you throw him into the guard room of your office and then continue to perpetrate, you know, the the violation of his fundamental rights to freedom, and then you then put the company again into further losses? That would be an unfair labor practice. Now, when you terminate an employee's employment on the basis of trade union activities, and this can be tricky because trade union people can be very, very, very worrisome in any company. They are the ones, look, sometimes they just come and you just resume in the office, you've done your makeup, you're looking good, you sprayed your best perfume, it's going to be a good day, and then you get to the front of your office and it's locked. Employees are outside, people are carrying placards, you no go gree, you no go gree, and then nobody is to enter the office. I wondering what's happening, and then you're found out that oh, they've locked everyone out, the employees are demanding this, employees are demanding that. Those of you that are working with companies where you don't have unions, you obviously don't know what the Lord has done for you, and but you see that and then you just decide, I'm going to fire this guy. And right there, outside there, you sent the termination just right where you were standing. In fact, your hands were shaking while you were typing on your phone. Be calming down because if you terminate someone's employment on the grounds of their involvement in trade union activities, that's an unfair labor practice. In fact, the international labor standard is that if you give an employee a reason for termination, and that reason is that they were involved in trade union activities, that termination itself becomes invalid. This is one of the few instances where the National Industrial Court will reinstate an employee who is in private employment for being wrongly or wrongfully terminating them on grounds of trade union activities. It is an unfair labor practice. Of course, the next decision was Agile versus Fidelity Bank, when you subject your employees to retroactive policies so as to deny them of accrued benefits. I'm sure some of you would know what this means. An employee, you have promised them that if you work with us for 20 years, you're going to, or let's even reduce it. Let's not make it too long. You say if you work with us for 10 years, you're going to be entitled to long service award in the sum of 50 million naira. See, the problem I've always found is that many of these companies who make these promises, they don't have these funds sitting anywhere. They have not made plans for these funds. They just say it because they want the employees to stay with them. And then an employee sees it and locks in on it. And then you've even forgotten that there's such a thing in your employment handbook. And then 10 years later, you writes to say, oh, you had said in your employment handbook that I'll be entitled to the sum of 50 million naira if I stay with the company for 10 years. And then they call you, HR, this thing cannot fly. You don't have that kind of money. And trying to save the day, HR puts another policy, amending the previous policy, canceling the long service award. It's an unfair labor practice. Whatever has accrued in favor of an employee, it is only that employee that can waive their rights to it. So rather than canceling, you better go and start begging. Begging, might give him corn, might give him cassava, maybe gari. I understand these are the things that are really, really, let me not say what I wanted to say. But whatever it is that you can do to help them, you know, waive their rights to it, or give your company if they are willing to. They are the only ones that can decide, okay, fine, I understand what the issue is, okay, fine. And of course, that's where dialogue comes in, what the National Industrial Court calls participatory democracy. That's where it comes in, really, because you then involve that employee to make them understand that, look, this is the challenge we're having. We don't have 50 million to give you. Can we give you five? Can we give you 2 million? Can we give you 1 million? Can we spread? Okay, we can give you 50 million, but can we spread it across a number of years? Finding a way to make sure that the employee feels heard, feels understood, and not just changing the policy and then saying, "Oh, actually, you're not entitled to this." If you do that, that's an unfair labor practice, and you pay heavily for it. I don't want to bore you today with how much companies have had to pay huge sums of money because of things like this. Now, for those of you who are HR personnel in banks, this happens a lot. Many times, you just place a lien on your employee's account uh, for funny reasons, just because. feel that is where you, oh, of course, at the points where they were joining the bank, you've told them that they cannot bank with any other bank apart from your bank. Remember what we said before, that's also an unfair labor practice. But knowing that they have most of their funds housed in your bank, when they want to leave, sometimes it's not even a bad leaver. This person might even be a good leaver, but because you find that they're very crucial to the operations of your bank, you want to find a way to make their departure very, very, uncomfortable. Then you just place a lien on their account. Doing that amounts to unfair labor practice. Withhold terminal benefits simply because someone has not submitted a handover note or has not done an exit interview. If that is not in your employee handbook and you do that, it's also an unfair labor practice. There's a case that I remember that I did at the National Industrial Court. It's also unfair labor practice for someone to say his name is Shegun and I'm calling him Shege. And he says, I don't like to be called Shege. Or someone's name is Femi and I'm calling him Femo. And he says, I don't like to be called Femo. And you continue calling him Femo. It's an unfair labor practice. And the interesting thing that happened in that case was that the person's name was Sheikh Wadraogo. It was it's from Burkina Faso, but a dual citizen of Burkina Faso and Canada. And then he came to Nigeria to work for one of the ride-hailing companies. And then his boss was calling him Drogo. If you remember, Drogo is the barbarian character in the Game of Thrones series. And the guy says, I don't want to be called Drogo. My name is Wadrago. Besides, there's Sheikh. Sheikh is easy to pronounce. Why do you insist on calling me Drogo? But sometimes in Nigeria, we just feel these things are jokes, and then they just continue calling him Drogo. And Kasala boss somehow stood them. We won because someone refused to call Femi Femi and insisted that Femi must be called Femo. It's an unfair labor practice. Now, if you refuse to issue work reference, and I see what some of you are doing, because I see what some of you are doing. I'll tell you what happened recently. Recently, a work reference was issued to somebody. The person had exited the service of this hospital, and what happened was really, really very, very petty. The head of HR wrote work reference and then said, this person said it was for so and so duration, from so and so time to so and so time. And he has now exited our company. We are not interested in rehiring him. What does that even mean? Why was it important for that information to be in an exit, reference? So while the court has held here that if you refuse to issue a work reference to an existing employee, if you write nonsense, that because look, the rule for work reference is that whatever you place in a person's work reference must be a fair and accurate depiction of the circumstances of their work with you. And you cannot write a work reference in such a way as would deny that person of the opportunity to get another job elsewhere. Now, the emphasis is fair and accurate. Fair and accurate. If the person was a thief in your organization and a subsequent organization writes you to say, oh, can we know how this person fared when they were with you? Then you are at liberty to say what you know about the person's work when they were with you. But do not go ahead and hinder someone's chances just because you want to be vindictive. And if the person did stuff that you did not confront them with, right, when they were with you, you didn't confront them with it, you didn't have an opportunity to defend themselves against that allegation, you as the company have waived your right as regards that infraction. You cannot use it against them when you're writing work references. If you write a work reference that hinders someone from getting a job, and brothers and sisters, you'll be paying them salary for that period where they were unable to get the job. So do not fail to issue work references to existing employees if they ask for it. Of course, look, they don't even need to ask for it. Just make it part of your policy. When they are leaving, give them a work reference and let them go. You don't need to know where they are going to. Just write it to whom it may concern and let them go. And don't write rubbish in people's work reference. Don't Don't write things that will make it impossible for them to be hired by someone else. Of course, again, denying people of entitlement that have accrued to them would be an unfair labor practice. Of course, the gray areas. Part of the things I've been saying, some of them, of course, appear to you as not being so obvious, to be called unfair labor practices. But you recall that at the beginning, I said that there are two definitions that I gave of unfair labor practice. I told you that the first one is it's rooted in the labor laws. And then I told you again that there are ratified and unratified international labor conventions. The unratified international labor conventions are evidence of international best practices. The ratified ones, the National Industrial Court has the power to apply them. They are also evidence of international best practices. That's ratified International Labour Organization conventions, and you should familiarize yourself with it. There are so much. I told you earlier on, there are 190 of them. Some of them are employee specific, some of them are labor specific. Labor in the sense that they are conventions related to, group employees, the rights employees enjoy as a group, as against the rights employees enjoy as individuals. But then look at the structure of the organization to understand which is which and which should ordinarily be applicable to your organization. And then you can, zero in on those particular conventions to be able to help save your organizations. Now, I will not now go back to the various conventions, so don't waste our time. I've just brought out two of the ones that I feel that are, very common. Um, Now, some of you have nursing mothers in your organization, and sometimes you hit them with so much work that it's impossible for them to actually have time to breastfeed their children. Um, that is an unfair labor practice. The reason it's an unfair labor practice is because it breaches the provision of Article 10 sub 1 of the Maternity Protection Convention. Now, this is one of those conventions that I said are not even ratified by Nigeria, but they are evidence of good practice. Now, the fact that there are evidence of international best practice means that an employee can draw out a right from them against your company. It is the reason why you should advise your employers. Now, the fact that this particular employee is very crucial to your operations, must have certain things done at certain times, they must have intervals when they're allowed to go breastfeed their children. It is why it is even advisable for companies like that to have a crèche, you know, in the company so that ladies can just take a break, go and breastfeed their children, come back and continue their work. So it's not a case of them having to travel a long distance and then you don't want them to do that because you're paying, simply because you're paying salary. Again, if you terminate without valid reasons, termination of employment convention is also one of those conventions that is not ratified. But mind you, this particular convention has gained so much notoriety that the National Industrial Court has said it has been judicially noticed. So beyond the fact that it is just an evidence of international best practice, it actually has gained some status as what you can call law. So you have to be careful with it. Now, there are other things that I might not be able to tell you has arisen from any decided case or that there is a convention that speaks to it, but it's growing. The issues around these things is, growing. I know that for some pharmaceutical practice license, and then because they have to use the person as a superintendent pharmacist and all of that in a particular place, be careful as you tread with these things because this particular one I'm telling you about, it wasn't a decision, so to speak, but it was something that the judge said in the course of proceedings that employers holding the certificate of employees as security for the employment of the employee on tender, it should not be released until the employer no longer desires the service of the employee, is an unfair labor practice. It is an unfair labor practice. Some of you deny your employees the right to disconnect. Of course, when I mean some of you, I'm not necessarily saying HR personnel, but of course, you are aware that your employers do this. Employees on his way home, emails are dropping. And Outlook has made it possible for you, even Google, Gmail has also made it possible for you to schedule send, right? So you can actually, I know that many times, adrenaline for some employers starts to kick in from 8 p.m., 9 p.m. Some of them you start seeing their emails from 2 a.m. And then you are issuing instruction for the person to get back to you in an hour for an email that is sent at 2 a.m. Ah, you're playing with fire. You see, the right to disconnect from work is a right that they are pushing currently to be elevated into the status of human rights, especially because of remote working. Remote work has created um, a scenario where people are faced with, you know, a growing problem of just working on end because they are working from home. So there is a right to disconnect from work so that you know that you have placed your work time from so and so hour to so and so hour. Or if it's a flexi work environment where you have said, okay, you must put in 10 hours of work per day, you must put in 8 hours of work per day. The time you choose to do that work is up to you. If that's the case, then you have employees submit the preferred times they want to work so that you're not sending them work tasks outside those times. So denying your employees the right to disconnect from work may someday be declared as an unfair labor practice. These are those areas that they're neither here nor there, but then it's important you look into it. Now, if you create option rules for stock options that will never vest, regardless of the efforts of the employee and the longevity of their time with your company, that's obviously a an unfair labor practice because you have created a benefit scheme that will never crystallize. So it's just like you'll be chasing shadows. That is obviously an unfair labor practice, and it's just a matter of someone getting tired of this growing trend and suing your company to get benefits from you. Of course, I know it has always been employer, 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 and you might be wondering, how about the employees? We some an employee, so I'll keep it on that out. But there's one that's been happening recently. People just take loans from their company and then they japa. No plans to pay back. In fact, there's this meme, I don't know if some of you have seen it, of a guy who was given the award of best employee of the month, but his flight out of Nigeria was the very next day. And there was a way the guy kept his face. I wish I was able to see that meme. I would have shared it on as part of this my presentation. But employees taking loans from their company and running out of the country outside the jurisdiction where the recovery can happen is an unfair labor practice. It's also an unfair labor practice for you to know that you're planning to leave the company and you're allowing them spend money on your training. You know, you're about to japa next month. They've sent you on a 2 weeks training to Canada because they need you to be able to solve some things. And then you come back and then you update your CV and then you tender your resignation. Come on, that's unfair. And it doesn't have to do with whether or not you were bonded to go on that trip. It's also an unfair labor practice. Now, what's the responsibility for HR personnel? Well, I've always advocated that you should seek legal counsel from labor and employment law experts. I've always said that it's not that you're seeking counsel from a lawyer. You see, the field of law is very wide, and you really cannot have anybody be a know-it-all. Nobody knows it all. So you have some persons who have dedicated their practice to a focused number of practice groups. So you do your research and find out who is the labor and employment expert in the particular firm you're trying to um, you know, give the work to so that you get specific advice that is, tailored to what you actually need. Again, keenly follow the decisions of the National Industrial Code. I always say this, the website is free to use. The decisions are updated on that website as they are delivered most of the times. So you have a situation where a decision is delivered today by 10 a.m. and later the next day, it's already up on the website. So you actually have real time, access to what the current position of the law is. Then again, incorporate international best practices into your employee relations policies, your employee handbook, your collective bargaining agreements, so that it's easy for employees to actually make claims for unfair labor practices, because they already know that, well, this is part of the contract and you have breached, my rights. Lastly, advise your company to employ a legal officer trained in labor and employment law as part of your HR team. It's actually very important that you do this. When HR gets it right, as I conclude, employees are better for it. Thank you very, very much for the time. I'll now hand over to Mr. Dioption.
Thank you so much, Barrister. That was excellent. That was super. I can see that someone has already dropped the meme on the chat group. Thank you so much for screenshotting and so generously sharing with us. We would like to take a few questions and comments or contributions as may apply. If you quickly like to take advantage of Barrister tonight, any request from tomorrow will attract invoice. I see Emmanuel's hands up. So Emmanuel, we give you the floor. If you would like to ask questions, please let's see all hands up right now so that we can.
Okay, also good evening, sir. Thank you, Barrister Emmanuel. That was an insightful class. We really enjoyed the class. Thanks for the exposure of a lot of things about Nigerian unfair labor practice. So my question now, hello sir, can you hear me?
Yes, I can hear you, although your background is a
Oh,
little bit noisy.
okay. My question is actually about the unfair labor practice, whereby statutory deductions is not being remitted to the appropriate authority. I've worked in an organization where statutory deductions are made. I work with the HR team. So my line manager is aware about this, but probably the HR team is scared of the top management. You see scenario whereby statutory deduction is being deducted from employee salary on every month, but it is not being remitted. Even when employee actually exits the organization and request for this money to be paid to them, it's not actually paid to it. So I don't know how we can actually curb this, or what are the legal action we can take to curb this in the organization. Thank you, sir.
Thank you very much. So it depends on the particular statutory deduction you're referring to, but whatever the case is, you actually have, so of course we know majorly you have two of them, maybe three, but depending on the organization you're working for and what they actually subscribe to, but generally pension and taxes, it is a crime for your employers to deduct and not remit. It is a crime and there's punishment for it under the relevant tax laws. And of course, for employees, it's really the tax laws of the states. Like for instance, Lagos State is the Lagos State Internal Revenue Service Law. Sorry, the Personal Income Tax Act also applicable in that instance. Now, if they fail to remit, I don't like saying go to court anymore because you guys have people have made go to court a joke. These days. But you see, that's a very great avenue through which you can actually get those things back. For pension, for instance, you're even going to be entitled to interest to be paid on, that part that has not been remitted. Interest is payable on it. So you might as well be sitting on your rights. And of course, you can actually escalate to the pension commission if you have written to your employers and they've done nothing about it. I mean, if we learn anything from Gen Z, it's the fact that they like receipts, you know. So right to pension, PENCOM rather, that's the National Pension Commission. Write a physical letter, take it there, get it stamped, you know, and scan the stamped copy and send it to your company, via email, and see if they will not respond. Sometimes they know that, it's like you're still joking. They don't really think you're taking it seriously, you know. So they're just waiting and they're looking at you to see if you're going to take it, seriously. It was deducted from your salary, so they have to remit both the one that was deducted and their own contribution, as far as pension is concerned, must be remitted. And so if you escalate, the pension commission can actually sue them for that and get back every dime that is unpaid, both for the employee and for the fund. Of course, well, let me not extend the question to that extent, but that's what you can do. So, yeah, of course, you can also get a lawyer, right? You can also get a lawyer, but then I understand that some of you might be constrained by funds. So of course, read the laws and do what you can do within your own means to see to it that you get your rights. You enjoy the rights that have already accrued to you. I hope that answers your question, man.
Thank you so much. Mr. Waliu, we would like to invite you to speak. Ensure you are in a conducive environment so we won't have interference. Mr. Waliu, if anyone has questions, please type or raise your hands now. Otherwise, you will meet Barrister Emmanuel in court.
Good evening, Barrister Emmanuel, and thank you for taking us through employment relations and the enabling laws governing the management of employees in the workplace. I would like to ask a question concerning group of company that has subsidiaries under it. We have a group of companies that its employee relations policies are still domesticated with the subsidiaries. However, work is ongoing to make the policies reflective of the peculiarities of the subsidiaries, but that has not been achieved so far. My question is now that are there legal implications for this, whereby we don't have clear-cut policies for the subsidiaries, and most times references are drawn from the parent company? Are there legal implications for this? That's my question. Thank you.
All right. So what you should understand first is that both your contract of employment and the employee handbook that you get in your place of employment form your contract generally. The offer letter, the employee handbook, internal policies of the company on employee relations, and all of those things jointly form your contract. So if you're in a situation where you have a contract, but no employee handbook was issued to you, right? It then means that it can be said that there is no employee relations policy, or so to speak, applicable to you. However, if there is a policy that is being used in relation to your employment, like you said, so let's say company A is a holding company that has B, C, D, and E under it as subsidiaries. Now, whenever issues arise, HR refers to the whenever issues arise in B, C, D, and E, HR refers to the company policy of the holding company. It then means that that is the policy applicable to the employees in both the holding company and the subsidiary companies. So whatever it is, let me even maybe break it down further. You have a situation where they keep saying in accordance with paragraph so and so of the so and so employee handbook. Meanwhile, you are not employed by that particular company. It then means that there can now be a sort of common control sort of employment where you have a tripartite relationship where you have your own employer, another employer, because it's sort of like a chain has been created by that, application of the employee handbook of, the holding company. or however the case may be. So it doesn't mean that you do not have, employment policies that govern your relationship with the company. It just means that the employment policies of a different company, which is not your company, but which is an affiliated company, is applicable to you. And it then means that you, as an employee, can draw your rights from that other company's employee handbook. I don't know if that answers your question.
Thank you so much, Barrister. We have a few questions from the chat box, and then we'll call it a wrap. Okay. One of the questions I can spot here from Abisoye here says, thank you, Barrister Emmanuel. Is it an unfair practice to bond employees to an organization for a specific number of years because of the trainings the employer provided to the employees? And can employees sue an employer if as a result of the penalty because he signed a contract with respect to the bond?
Okay, so again, the principle here is that contracts are sacrosanct, and you cannot resile from a contract simply because the terms have now become onerous or the terms have now become difficult. You see, you must be careful with bonds because the current state of the law, as far as the National Industrial Court is concerned, is that the court will enforce the bond. But then the extent to which the bond will be enforced depends on the particular factual circumstance of the case before the court. Now, let me explain it this way. If you go on the NICN website, if you read the Overland cases, because Overland is one company that seems to have suffered a lot from, training pilots and then the pilots deciding that they want to leave to go to a rival airline, right? So you see a number of cases, even as recent as 2023, Overland cases. Now, if you sign a bond that, look, the employer says, we're going to train you for this particular certification and this particular certification. In lieu of this training, we require you to serve us for 4 years. We require you to serve us for 3 years. It then means that there's an amortization scheme in place, which means that the value of what was spent in training you would be reducing as time goes on. If you want to jump ship, and that is where your negotiation skills will come in. If you're changing jobs, inform your new employer or your new prospective employer that, look, I have been trained here, and this is the amount of money that was used to train me. Do you mind paying them back if you really want me to jump ship? You could put it in as part of your negotiations. But if you jump ship, you would have to pay, oh my brother, you have to pay. However, there's a decision of the National Industrial Court where the employer could not prove that they actually spent the amount they claim to have spent in training that employee.
Hello, Barrister, are you still with us?
It do not count to be able to put you in a bond, right? So it depends on the facts of each of the cases. And you may be able to get out scot-free, you may not be able to get out scot-free, depending on how the particular case goes. That's really what will determine whether or not an employee would be compelled to pay the bond.
Thank you so much, Barrister Emmanuel. So in other words, in a layman's language, if you are bonding, the bonding must be reasonable and it must be market cost reflective. Not that maybe you actually spent 1 million naira to train the person and then you now claim that it's 20 million naira. There must be evidence to show funding and it must be reasonable. Thank you so much. I see a question here, but it is to me directly and it is long. It should be on the group so that barrister can read it directly. Okay, let me see. I'm not sure. I think network has taken barrister out. There was one question I wanted to ask barrister, but let's see if he is able to come back. If not, it will be a convenient intersection to call it a wrap so that we can prepare for tomorrow. All right. I'm not sure they will be able to join back. Ladies and gentlemen, thank you so much for tonight. Have a good rest of the evening. Good night, everyone. Bye for now.
Thank you, sir. Good night, sir. Value added this evening. Thank you so very much.